We're fortunate to have with us this morning a representative of the SEC to give us an inside look at what is going on. And I'm particularly interested in knowing what the impact of the new chair is having on what's getting done day to day at the SEC. And so with that, Sharon, can you please give us your views on that topic?
Sure. Good morning. Before I begin, let me start with the usual disclaimer that the views I express here today are my own and don't necessarily represent the views of the Commission or the staff. With Mary's helpful overview, I thought it would be appropriate to start with a recent quote from Chair White, which I think gives a really good flavor of what the SEC's agenda is right now and what you should expect to see coming out of the Enforcement Division. She said that the SEC as an agency must be aggressive and creative in the way we use the enforcement tools at our disposal. That means we should neither shrink from bringing the tough cases nor fail to bring smaller ones. When we detect wrongdoing, we should consider all the legal avenues to pursue it. If we don't have the evidence to bring a case charging intentional wrongdoing, then bring the negligence case that does not require intent. And when we resolve cases, we need to be certain our settlements have teeth and send a strong message of deterrence. That is why in each case, I've encouraged our enforcement teams to think hard about whether the remedies they are seeking would sufficiently redress the wrongdoing and cause would-be future offenders to think twice. So it's a pretty tough message, and I think to Kevin's question, the Enforcement Division, this is a great time to be there if you're an enforcement lawyer. There has never been a more clear and strong message that we have the support to go out and to be, as Chair White said, aggressive and creative. And there are a lot of new initiatives right now to achieve the goals that Chair White has expressed. And there's probably not enough time today to spend on discussing all of those goals and the priorities, but I thought I would start just quickly with an overview of a couple of significant post-Madoff, post-financial crisis changes, and then move to, with that as a backdrop, some of the initiatives that are significant at this time in the agency that I thought might be of interest to you. They're by no means the only initiatives, but I think they're significant ones. So just as a quick overview of changes that have occurred in the past 5 years, there have been significant advances in technology, investigative techniques, and risk assessment. I'm not sure if anybody saw quotes from the chair's remarks yesterday where she highlighted two particular technologies that we expect will dramatically change the way that both the exam program and enforcement can conduct data analysis more quickly, more efficiently. And so the technology is a really significant change. The nationalized specialized units were created shortly around 2010 and have been a remarkable change to the Enforcement Division. We've hired industry experts who are on the cutting edge of industry trends and are more proactive, and as a result, the Enforcement Division is more proactive in detecting fraud. Cooperation is a really significant area and one that we can go into further detail about. The agency has really taken steps to encourage cooperation by insiders. And also the whistleblower program is changing the landscape of how we do our business. And finally, enhanced risk assessment makes us smarter and more efficient in terms of how we identify and therefore pursue fraud. So with that as a backdrop, I wanted to start with one initiative which covers a lot of different areas, the focus on gatekeepers. Gatekeepers meaning board members, auditors, lawyers. There's an agency-wide initiative to really focus on the people who could prevent the fraud if they were properly doing their jobs in certain circumstances, certainly not in all circumstances. But one example of a gatekeeper is a board member. And you may have seen that there have been two recent cases where the SEC charged trustees of boards of investment companies. And in those cases, the trustees were simply not doing their jobs. They weren't asking the hard questions. They had not properly reviewed, for example, in the Northern Lights recent case, the core of that claim was that reports to shareholders from the trustees contained misleading information or omitted material information about how trustees evaluated certain factors in reaching their decisions to approve contracts on behalf of the funds. And I think one of the egregious examples there was that the materials had disclosed that trustees were looking at peer comparables and that the fees were in the range of the comparables. And in fact, no material of comparables had ever been provided to the trustees. And in fact, the fees were well in excess of the peer comparables. So that's one example of gatekeeper
Can I ask you a question, Sharon?
Sure.
Just because I know everybody in this room, their radar went up when you mentioned that the SEC is focusing on board members. And there are a lot of different ways that there's focus on board members, a lot of areas of the law, not just securities laws, environmental law. And I've personally been troubled by a trend where regulators are going against board members who not only had no involvement in the misconduct, but were not even aware of the misconduct. And I've always been worried that it starts to get not just too far afield, but too far from sort of the basis of our legal system where the whole idea is only guilty people are held responsible. And if they weren't guilty, how can they be held responsible? It troubles me, and I'm wondering where the SEC comes down on that.
Sure, that's a fair question. And I think, let me start by giving you a quote that might be illustrative that the chair recently stated in a speech. She said, "It has been suggested that our focus on gatekeepers may drive away those who would otherwise serve in these roles for fear of being second-guessed or blamed for every issue that arises." She said, "This is my response. First, being a director or in any similar role where you owe a fiduciary duty is not for the uninitiated or the faint of heart. And second, we will not be looking to charge a gatekeeper that did her job by asking the hard questions, demanding answers, looking for red flags, and raising her hand." And Kevin, to your question, I think the second part of the chair's response is very illustrative. And the Northern Lights example that I gave you, I think it was the SEC's contention that those trustees were not asking any questions. They weren't asking the hard questions, but they certainly, it didn't appear that they were reviewing the disclosures and having the relevant information and making sure that they were asking the right questions. So I do think that our focus is on those who are simply failing to do their job as opposed to trying to second guess the directors for the questions and the judgments that they are making.
You know, one of the things that Mary mentioned that I know is also of great interest to this audience is the SEC's new policy on admissions. And I know that there have only been a few cases so far, and it's hard to generalize, and it may also be difficult for you to talk about other than a very high level of generalization, but what can you tell this audience about that policy, how it will be implemented, and what kind of cases it will be a factor?
Sure, so let me start by saying that the first case that was brought with an admission was in August of 2013. So this is new. And it's evolving, and I think, like with many things, we're going to have to wait and see how it develops. However, with that said, there have been certain principles that have been set forth for the types of cases in which we may require admissions. The categories include cases involving misconduct that harmed large numbers of investors, or placed investors or the market at risk of potentially serious harm, where admissions would safeguard against risks posed by defendants to the investing public, particularly when they engaged in egregious intentional misconduct, and finally, where a recitation of unambiguous facts is important to send a message to the market about a particular case. And so I think the recitation of facts piece is important because Chair White has also said that there is some kind of public accountability that is often desired and demanded. And in those types of cases where we feel like we can't get that kind of public accountability without a clear admission to the facts, admissions, that is one category of case where admissions may very well be required. And if a party is not willing to give an admission where the commission feels that that is the appropriate course, it has been made very clear that we will litigate in order to secure the public accountability through the airing of the facts.
So I think for the folks in this audience, there are a lot of concerns, but one is that the SEC enforcement proceeding is only one of several legal matters involved in the same set of circumstances. And it's quite alarming for the lawyers, I'm sure, that are involved in the case, that an admission that may be required by the SEC could have a collateral effect in the other proceedings. To what extent is the SEC taking that possible impact into account?
I think it's fair to say that that's not really a consideration of the SEC. That's outside of our mission. First of all, the extent to which the admission may be used in related procedures is one that's up for the courts to decide. Our interest is in obtaining admissions. The interest is separate and apart from their admissibility in the collateral proceedings. Investors should be able to recover damages in civil litigation in appropriate circumstances, but our mission is a different one.
So in the spirit of the more aggressive and creative enforcement division, I think you'll see several things that I would anticipate coming out of the enforcement division. First, an area that we didn't really get a chance to talk about today, higher penalties. I think some of us think that maybe the comps of yesterday are a little bit out the window, and we're starting off in a place where, as Chair White has said, we want to send a meaningful message of deterrence, and you have to feel it. So I expect that you will see significantly higher penalties. Admissions, same theme. We've talked about those, but I do expect that we will see more admissions down the road. Cooperation agreements. There was recently a non-pros agreement with Ralph Lauren in the FCPA context. We just had our first deferred prosecution agreement against an individual. There is going to be a very high emphasis placed on cooperation and the benefits to individuals and entities in cooperating. And so I think that we will continue to see efforts to use our cooperation tools effectively, which will, I think, in turn, create benefits to both companies and individuals who do act proactively to cooperate, who self-report, who provide meaningful, full, truthful information. The whistleblower program, very similar. I expect that we will see payouts down the road in addition to the ones that we've paid out already. I think the largest to date was $14 million, but we received, I believe, somewhere in the range of 3,200 whistleblower complaints in fiscal year 2013 alone, which is a staggering amount, and many of them have yielded very useful information, and so I expect that we will see additional payouts in the future. And the last is an area that I've covered already, which is more gatekeeper cases. There is really a focus on auditors, board members, lawyers, across the board. I would expect to see a continued focus with additional cases down the road.